Mentioning from the list. Are you mentioning?
Call the list.
Item number 1, W6044 or 34.
And for the petition. Your Worship, my first point is that in the first round of litigation, this is a matter relating to disciplinary proceedings. Now, the first round of litigation,
What is the stage of the proceedings?
Finished.
Oh.
Finished. Appellate authority also passed an order challenging which.
What was the order passed? What was the punishment order passed by the dismissal?
Yes.
Then what is the scope?
There, that's what I'm saying. First round of litigation, Worship, when I have challenged disciplinary appellate authority's order, this travel up to this honorable. This honorable court found that a statements which were recorded during preliminary inquiry. Exactly that statement was there, and thereafter 2 lines in the examination in chief and then cross-examination. And they relied completely upon the statement which was there in the preliminary inquiry. This honorable court held that it cannot be done. You have to examine them again. This is the observation finding of the order. An entire thing was set aside. They repeated it. They repeated the thing again during the second inquiry. Same thing statement was there.
What was the order of punishment passed?
Dismissal.
Let it be heard on filing of paperwork. You have challenged the order of the tribunal, just one. Where is the order of the tribunal, Ms. Nath?
416.
Why it has been repeated? Same
It's a well considered order. Kindly consider the cat's order now. Everything is considered, my lord. In fact, scope for interference, my lord.
It's not an ornamental punishment order. Application of mind was there.
Yes, my lord. Appellate.
Where is the order of the tribunal, which is under challenge?
416.
Page 416.
Yes.
The part 2.
Petition, my lord. Actually.
416. February 2024.
Yes, ma'am.
Now the tribunal has upheld the final order of punishment.
Yes.
And disposed of.
Yes.
Writ petition. The present writ petition is filed inter alia, challenging the order, final order dated 9th February 2024, passed by the Central Administrative Tribunal, Kolkata bench, on an original application being OA 351/00190/2018, whereby order of the disciplinary authority, whereby petitioner was dismissed from service, was upheld. Stop. Miss Anjali Nag, learned senior advocate representing the petitioner, submits that the order of punishment was subsequently affirmed by the appellate authority, which prompted the petitioner to approach the tribunal, questioning the order of the disciplinary authority as well as appellate authority. Stop. Stop. Next, having considered the submissions made on behalf of the parties, we find there is no scope for passing interim order. Stop. Let the writ petition be heard finally after filing of paper books. Stop. Let the paper book be filed by 4 weeks.
Yes.
By 4 weeks from date. Stop. Learned advocate for the petitioner is directed to serve copy of the paper book upon the learned advocate representing. You are the only respondent.
Yes, sir.
Upon the learned advocate representing the respondents by 10 days thereafter. Next paragraph. Let the writ petition appear under the heading hearing after the time fixed herein above for filing paper book and effecting service of notice with the paper book upon the learned advocate representing the respondents. Stop.
Right.
Item number 2.
27 of paper book is not. I'm sorry, Ganesh. Actually, it was prepared and given, but copy has not.
Copy is not given.
So it can be taken up in next circuit.
Yes, so I have a copy of the paper. Yes. At the time of call, learned advocate representing the petitioner submits that though paper book has been filed pursuant to the direction passed by the coordinate bench, passed by a coordinate bench, but copy of the paper book has not been served upon the learned advocate representing the respondents. Stop. Let the paper book be served upon the learned advocate for the respondents by 7 days from date. Next paragraph, list the matter before the next available circuit under the same heading or under the heading hearing. Under the heading hearing, not same heading.
Mostly.
Item number 3. Committee 2 of 2025.
My lord, I have nothing for the appellate, my lord. I have challenged the order passed by the. My lord, this is asking, my lord, for all the documents.
What is the can for?
Can, my lord, actually what happened, the order was passed by the learned single judge in my absence. Therefore, I have taken out the can application seeking to recall the order. Then the court said it would be appropriate if you file it before the division bench. So that, then I withdrawn it. And that's why these facts are not there before the.
Let us consider the order which is under appeal. But both the parties were heard.
No, my lord, my junior was there, it was not. That's why I filed this appeal, because I was not there, my lord. I was arguing before the court number 1. My junior was there. And my lord, that's why I have taken an application to recall first. Then the court.
You were appealing for the petitioners. Petitioners and petitioner was represented.
My lord, that was recorded. My junior was there. I was not there. Even when the matter was over, I went to the court and requested that I may be heard and order may be passed. The court said already I have passed the order, therefore.
Then you took out an application before the court, before the single bench.
Single bench to recall. Then my lord Justice Amrita Sinha said it would not be appropriate, you prefer now. Then I withdrawn it. I was not heard. Because the order itself speaks, because I also taken, no, my case was that in terms of the said notification, they have paid 3 lakh, which is much lesser than, this is my, that notification is part of my writ petition. It is not that they have produced the notification. My contention was that since.
This notification dated 12th August 2015.
Yes, that was the part of the writ petition. That was annexed to writ petition. It is not that I have not placed it and they have placed. This is what the court has passed the order. It was annexure in the writ petition.
You could have annexed the same, oh, you have annexed
Yes.
the notification.
But it was said it was 1,50,000 as per notification.
That was what we have challenged before the writ court.
So why you are saying 3 lakhs was paid? 2 persons died. 2 persons died.
2 persons died because
Yes.
they are fault, my lord. What happened, my lord? A banyan tree was stand up.
But the thing is this, Mr. Kumar,
Hello.
as it appears that the notification was not taken into
No, my
consideration. Question of being
lord,
different.
since there is a notification, therefore they cannot pay more than that. My entire case lies on that this notification, in terms of the notification, the payment which was made, it is not commensurate to the death caused to.
But the learned single judge has said that the notification is not under challenge.
We have not challenged. This is
Then-
only, that notification was only an exit period. It was not a notification.
So if are you disputing payment and was not made in terms of the notification?
No, we say that.
But if you are not disputing payment not made in terms of the notification, in that event you have to demonstrate before us today that the notification was under challenge. Then
My lord, this is.
what is the wrong in the order?
This is only an executive fiat, my lord. Only an executive fiat. Now, my lord.
Show me from the writ petition that you challenge the notification.
My lord-
Otherwise, there is no scope.
My lord, may kindly see my CAN application because this document, my lord, may.
Yes, already.
And you appear, it is not a case that you appeared on behalf of the respondents. Then we could have considered the issue that the matter should have been dealt with after exchange of affidavits. It is not a case. You appeared for the petitioner.
My lord, the affidavit was filed. Affidavit was. My lord,
Affidavit was exchanged. Yes.
My pleadings was not, my reply was.
Only thing, Mr. Kumar, you have to demonstrate before us today that you challenge this notification dated 12th August 2015
My lord, may kindly come to.
from the writ petition.
My lord, may kindly come to my CAN application page 20. Similarly, circumstance person was paid 5 lakh rupees in 2021 by the same administration. Kindly come to page 20 of my CAN application, which is filed before my lords. Kindly come to that, my lord.
Page 21 of
20 of my CAN application. 20. Before that, if my lord.
Reporting.
it's a newspaper report.
Newspaper reporting.
5 lakh rupees was paid by the administration.
How from
My lord.
get it? Yes, right. The compensation released to the family.
5 lakh rupees.
It is-
Now, my lord, 20.
No, it is crocodile attack.
Yes, my lord, now kindly come to page 20.
You does not fall within
Yes,
that
yes,
category.
I fall, my lord.
You fall page 18, roll number 4.
And crocodile is page 18, number 1. There also the amount is 1.5.
So that is a different case.
No, there is also, my lord, kindly see page 18 once.
Was injury due to
Serial number
crocodile.
1 is crocodile attack.
Serial number 6 is accidental permanent, then grievous injury due to crocodile attack. Serial number 5.
Serial number 1.
And injury by falling of trees, where it is.
My lord, serial number 1 is crocodile attack, page 18.
Page 18, grievous injury due to crocodile attack.
Number 1, serial number 1, ex gratia. Crocodile attack, 1.5.
Then where is the provision relating to payment of compensation due to falling of trees? 4.
1 and
Ex gratia payment of family
Well,
decision.
they have the crocodile attack, why not to the, my lord, this.
The issue is not said,
No,
Mr.
this should
Mr.
stay,
Kumar.
my lord, may kindly see page 18, serial number 1 and 4.
And you have not challenged that notification.
No, my lord, 1 and 4 are same.
Well, is it your case? Would you be able to demonstrate before this court that you questioned this notification dated 12th August
My contention was that
2015?
there are several Supreme Court judgment whereby on similar circumstances, the court said for the loss of life and limb, it cannot be, this amount cannot be sufficient. And my lord, here there are two aspects. First, I will rely upon
No,
those judgments.
here your right comes from this notification.
My lord,
Now, if the notification is not, was not assailed before by filing the writ petition, where is the scope of delving into the issue which you are raising today?
my lord, same notification, serial number 1, crocodile attack 1.50, same notification, serial number 4, 1.50 for tree fault. In both the case, the amount is 1.50. They have paid 5 lakh rupees. Why this discrimination, my lord?
No, why it is to be sent back to the learned single judge
No,
for consideration?
I say that paper book may be prepared. I will argue on merit.
Only discrimination. Now discrimination is there. Actually, we being the court or judiciary, we cannot increase the amount fixed by the.
Right, my brother has rightly said.
Okay.
No, your point is this, that the petitioner was not represented by you, but by your junior. Now, if yes, that is the accepted situation. That is the situation, indisputed situation. Even then, had you appeared on behalf of the petitioner on the date your writ petition was disposed of?
No.
Was disposed of. Then what further what additional points you would have taken?
I have not filed my reply because we were seeking time to file reply. I am not allowed to file reply. My lord, this matter, my lord, for 4 years, they took 4 years to file affidavit in opposition. Several courts come to my aid saying that you cannot.
Okay, you don't need to reiterate that point that I have not been given proper opportunity before the learned single bench to place my case. Now you place here.
My lord,
Okay, we are giving that opportunity. Okay, you say that the administration by issuing a notification says fixed determined amount, that in such event such amount shall be paid. Now judiciary cannot ask them to increase.
my lord,
Unless until the legality and validity of the notification dated 12th August 2015 is put on the
my
challenge.
lord, 2 parts are there. First
Yes.
part is that we are under a welfare state, wherein the welfare state has accorded the said benefit to an incumbent who ought to got 1.50, but they have given 5 lakh rupees. This is a clear case of discrimination. I could have accepted if it has been done by some department, not by the state. When the state is acting, the state ought to act in a manner where there can't be any scope of any discrimination. This is my first point. Second, my lord, there are judgments of the Supreme Court and High Court whereby it clearly says that if, my lord, a life has been
That is in motor accident case. Let me come the judgment, it was stated.
It is under the separate act altogether.
in Bombay High Court judgment.
Today, in sitting in the writ court or in the mandamus appeal, we are required to ponder whether in terms of the notification dated 12th August 2015, it is payable to you or not.
My lord,
And in the context where no challenge has been thrown to that notification.
that discrimination part, my lord.
Right?
Discrimination.
No challenge to the notification.
Equality among the equal. Equality among the equals.
We are equal.
You know very well better than the victim of crocodile attack and the victim due to falling off a tree upon her, him or her, cannot be equated. Can it be equated?
In page 18, they said that this would be amount paid to both. My once come to page 18.
Yes, we are.
Number 1 and
I am on page 18.
serial number 1 and 4, the amount is same. My lord, we are after. I am fighting for a life which has been because of the fault on the part of the authorities, my lord. There was a clear direction of the forest department saying that I have made a complaint. Forest department conducted an inquiry, and thereafter the forest department said this is dangerous. You
No, it is an ex gratia amount, whether the full amount was determined.
So this was the full amount.
This was the full amount.
Full amount there.
Now, whether any affidavit in reply has been filed.
No, I have not filed, my lord.
Okay, why you have discriminated? When same amount has been mentioned in the notification,
Yes,
that in this case, that amount shall be paid.
Page 18, my lord.
Huh?
Forest division now not the middle line.
Under the same administration.
Now, following the same notification.
State no. Not a.
Now,
No.
you compensated that victim.
It's a compensation.
It's not expression.
Now, my learned friend cannot say anything which is contrary to regard, my lord.
Yes.
We-
There, my lord,
yes.
this paper.
So he.
Paper extract.
My lord, at the end of the day, this is only the amount.
Even compensation that is not the expression of paper. It's just, as a notification.
Discrimination to justify.
No, discrimination does justify, not on the basis of the.
As per the,
That is,
Well, this document was-
we are required to consider based on this notification. So therefore, since. there
and
is-
forest department delays.
Since there is no pressing urgency, let them should be even reconsider the. Reply was filed, and without absence, in absence of reply, this writ petition was finally disposed of. We are remanding the matter back to the learned single judge for reconsideration after filing of reply.
And issue of discrimination as raised has not been addressed.
You're right. Yes. With the consent of the parties, you have filed stay application,
No, my lord.
appropriate order.
Yes.
No, it's an application for stay. With consent of the parties, appeal, with the consent of the parties, appeal being emitted 2 of 2015, 2025, and connected application being, being can 1 of 2025 are treated on days list,
Stay application.
are treated on days list and finally heard today. Stop. Next paragraph. This appeal is directed against the order dated. Order dated 5th November 2024, passed by learned single judge. Thereby giving certain reasons, the writ petition, the connected writ petition was dismissed. Stop. Next paragraph. On hearing the learned advocate representing the appellant today and on perusal of the order dated 5th November 2024, which is under challenge, it appears that petitioner was not satisfied with the quantification
payment.
it is not a compensation.
No, it's just a payment.
উপরে দেখো compensation for providing financial assistance in terms of notification dated 12 August 2015. There is an injury or death due to death of 2 persons since 2 persons, which was caused for falling of trees. Falling of trees. Falling of one banyan tree. Stop. Date of 2 persons. Please correct the sentence. Date of 2 persons caused due to falling of one banyan tree. Stop. Admittedly, rupees 3 lakhs within bracket rupees 1,50,000 each was paid to both the petitioners pursuant to the said notification dated 12th August 2015, but the petitioners are not satisfied, which triggered the present writ petition, which triggered the connected writ petition. Stop. main ground of challenge made against the order dated 5th November 2024 is discrimination on the part of the respondent authorities in releasing financial or in releasing financial assistance in terms of the notification dated 12th August 2015. Stop. It has been agitated on behalf of the appellants that in some cases higher amount of financial in some cases financial assistance of higher amount were released, but in contradistinction to the same, in the present case, a meager amount of rupees 1,50,000 has been paid to both the petitioners each. Stop. In addition thereto, it was also pointed out that affidavit in reply was not filed on behalf of but it was not filed. Yeah. In addition, yes. That we understand.
Is that there was not a chance to find?
Yes. Yes. Just a minute. That was not filed on behalf of the petitioners, but the fact remains as it is pointed out on behalf of the respondent authorities that opportunity was given to file affidavit in opposition, affidavit in reply. Stop. Next paragraph. Since it is a case of quantification of financial assistance in terms of notification dated 12th August 2015, we find that a chance needs to be given to the petitioners for filing of reply, for filing of affidavit in reply to the writ petition prior to final decision to be arrived at by the learned single judge. Stop. Next paragraph. We have perused the order passed by the. You have perused the order dated. We have perused the order dated 5th November 2024, where the learned where the learned single judge has observed that notification dated 12th August 2015, virus of the notification dated 12th August 2015 was not assailed. However, a point of discrimination has been agitated, and according to the petitioners, if they are permitted to file affidavit in reply, their case before the learned single judge might be improved. Stop. Next paragraph. In view of aforesaid scenario, we permit the appellant writ petition appellants / writ petitioners to file affidavit in reply, file affidavit in reply by 3 weeks from date, from date. Stop. However, we make it clear that beyond the period of 3 weeks, no further time is to be granted to the appellants / petitioners. Stop. After the period as fixed herein above for filing affidavit in reply, matter to appear before the learned single judge for final hearing for final hearing of the writ petition. Stop. No further prayer is to be allowed by the learned single judge for extension of time to file affidavit in reply. Next paragraph. With the above observation, the order passed, with the above observation, the impugned order dated 5th November 2024 is set aside, and appeal and application stand disposed of. The writ petition stands revived. The writ petition stands revived. Urgent xerox certificate copy. No, that how we can. We have dismissed we have allowed the appeal and we will say that we have not gone into the merit of the case. Then this order will be defective. To what extent we have applied our mind, that we have adequately expressed in our order. According to the chance of improvement of case on the point of discrimination. Yes, next matter.
Item number 4, 79 of 2025.
Sympathetic compensation. Yes, item number 5.
Item number
4, who is appealing for the petitioner? Who is for the appellant?
Appellant,
Naam ki
Bobita Das.
Divesh Divedi.
Bobita Das and Divesh Divedi.
Miss Das was there. Yes, Miss Das.
4, 5, 6, 7.
Why? You are appealing for the appellant. So why you are paying for time? Yes, tell us. You have not filed any application. What is the matter about?
Alternative land law.
Yes,
Not paid for the same, paying for signing paperwork.
but how that will help you? Because the order has to be interdicted. Otherwise, there is a specific, come to the internal page of internal page 3 of this order.
Yes.
In view of the court directs the Secretary Revenue of the Andaman and Nicobar administration to take a decision in the matter, that is either to return the possession of 0.70 hectares of land to the petitioners or provide them with the alternative land of equal value and location within a period of 3 months. And this order was passed when? This order was passed on 7 November 2024. So already November, December, January, February, it will expire. So if we today direct filing of paperwork, that will not any to your benefit. You are praying for time, we can grant you time. So come back in the next week. And why you have not filed an application?
Stay application, why you have not filed?
File an application for stay. Or appropriate application. Mere filing of appeal will not serve any
Yes.
purpose.
If you file stay application annexing the writ petition or all documents, the appeal can be disposed of.
But at this stage, simply giving direction for affidavit will not help you. Unless and until, because order, there is a direction that within 3 months it is to be, the exercise is to be carried out by the concerned respondent authorities. Where is your weapon? Where are your weapons to attack the order? Nothing. Today merely filing a grounds of appeal in the form of memorandum of appeal will not serve purpose. So let us fix the matter on next Thursday. In the meantime, you take steps. Otherwise, we need to consider it accordingly. At the time of call, learned advocate representing the appellants has prayed for accommodation. Stop. List the matter under the same heading on Thursday next. 6th February 2025.
Item 5, Blair of 2025. Item number 5.
Hey, same. He has said,
Yes, item number 5.
he has said 4 to 7. 4 to 7, same.
Call same order. Call one after another.
Item 6, May 11 of 2025.
Same. But this court is very slow. So therefore, one after another, all matters have to be called on. Yes. Then item number 6, please call.
Item number 6.
Have you served notice upon the other side? No. So, add another line. In the first matter also, nobody appeared for the writ petition and respondent. Add another line. In the meantime, learned advocate for the petitioner is learned advocate for the appellants is directed to serve notice upon the learned advocate, directed to serve notice upon the respondents or the learned advocates who represented the respondents before the learned single judge.
Item number 7, May 12 of 2025.
Same order.
Serve notice, take steps, come back.
Item number 8, May 2 of 2024.
For the appellant, yesterday I submitted that pecuniary jurisdiction of the district judge was by the order of
1,50,000.
1,50,000. That order is challenged before the Honorable Apex Court by the said party
For enhancement of pecuniary jurisdiction.
for quashing of that order, because entire appeals are filed before the London district judge without any limit. But this order, numbers of appeal, more than 100 appeals are being pending before the district judge. and my appeal was returned to file before the appropriate court. I challenged that order before the Honorable Justice Sugata Majumdar, but it was not interfered with. And then I have to take back up memo of appeal file here. But matter
On the
is that-
point of, since the pecuniary jurisdiction does not permit filing of appeal before the court below.
Yes, but subsequently, if matter is otherwise before the Honorable Supreme Court, then all problems will be created.
Just a minute. What is the interim order passed dated 14 November 2024?
It was passed, Your Lordship, for staying the impugned judgment and decree passed by the trial court,
By this court,
by this court.
High Court. Where is that order?
14 November 2024.
Yes, ma'am. Yes, just a minute.
Para 11 is.
Has returned order 7 rule 10. Huh?
Yes, Your Lord.
Only submission.
No, my submission was otherwise, even though.
How you have filed order 41 rule 1. It is order 43.
No, I.
Have you brought the CPC?
Lordship, because
It will
my
be FMET.
memorandum of appeal was returned to me. On
Order 7 rule 10.
that order was challenged before the Honorable Single Judge. That order was not interfered with. Then I have to compel to take back memo of appeal and file before this court. It will be first appeal before this Honorable Court. Because I am not challenging the order of return of memo of appeal now. I am challenging the order of the trial court.
Oh.
After taking back the memorandum,
Oh.
I this is 41 is coming.
Okay. I am under.
Indefinite period.
Other similar matter is fixed after March because matter is before the Honorable Court fixed in the month of March. 17 March, matter is fixed before the Honorable Supreme Court. I annex in
Just a minute, just a minute.
Suit for basically performance of contract. Plus degree.
Correction we cannot do.
Because
করে কি করবো না ইয়ে করে দিতে হবে চাইছে টাইপোগ্রাফ করে এটাকে নেক্সট সার্কিট করে দিলাম নতুন একটা এক্সটেন্ড করে দিয়ে দিতে
ইন্টিমার্টার till the disposal করে দেওয়া হলো নাকি ওদের ইন্টিমার্টার
না
shall be
টিল
extended
ডিসপোজাল না টিল ডিসপোজাল না
এই,
31st শেষে যাবে একদম 31st মার্চ করে record an order at the appeal no on hearing the please strike it over. Learned advocate representing the appellant prays for accommodation. Stop. Prays for accommodation since it has been submitted that on the point of pecuniary jurisdiction, appeal before the district judge.
Before the district judge has returned from it.
return
The appeal was returned, which prompted the appellant to present this appeal before this court. Stop. It is further submitted that on the point of pecuniary jurisdiction of the district judge,
Yes.
issue is pending before the Honorable Supreme Court. In another matter. Issue is pending before the Supreme Court in another matter. Stop. The learned advocate in another matter. Stop. Accordingly, prayer is made to adjourn the matter. Stop. Next paragraph. You are for the respondents. The respondents are represented today. Next paragraph. List the matter. দুটো সার্কিট স্কিপ করে দৌড় আমাদের তো চলছে
go out of list with liberty to mention নাহলে মার্চ
That shouldn't be, because if it is not taken up in the month of March, my clients will be impacted, the ultimate sufferer.
just a minute. List the matter before under the same heading list the matter under the same heading on 10th March 2025, subject to convenience of the bench.
Before the Honorable Supreme Court, matter is fixed on 17 March. I enclose that order.
No, then it will be after 17.
After 17.
Just a minute. List the matter under the same heading before the coordinate bench on
April circuit.
On 20th March 2025 for further consideration. Next paragraph. Interim order passed earlier stands extended till 31st March 2025. Next paragraph. 31st March 2025 or until further order, whichever is earlier. Next paragraph. On perusal of the records, it appears that in the order dated 14th November 2024, inadvertently it was recorded in paragraph 12 that the appeal was disposed of.
No, that was corrected.
It was corrected.
Subsequent order, 18 of November.
Very good. Yes. Next order, it was corrected. Since the issue is pending before the Supreme Court, wait for some time.
করেছিল ও অর্ডারটা মেনে নিয়ে অরিজিনাল জাজমেন্টটা দিয়ে এখানে চ্যালেঞ্জ করবে যদি হয় তাহলে অ্যাকশন আমি এখানে চলে আসবো এটা আনা করতে চাই ডিস্ট্রিক্ট বোর্ডের 1.5 লাখ পর্যন্ত পাই হাইকোর্টে চলে সেটা
ওটাতে মিনিমাম ছাড়া তো কোনো উপায় নেই, ওটা অ্যাপিল প্রেফার করতেই হতো। That point cannot be taken. Why? Because if this order was not accepted and appeal was not filed before the High Court, then his right would not have been protected by passing an interim order which has been passed in previously by the coordinator. Yes.
Item number 9, WPC 19 of 2024.
Appeal of the other side. Here, my lord, the learned tribunal has rejected on the ground, has not granted full relief on the ground that an appeal is pending before the appellate authority. That is the President of India. The old matter, my lord, I was wondering if, my lord, it may be appropriate to first find out the status of the appeal before the president, my lord.
So then you have to apprise this
I will
court.
apprise, my lord, may keep it.
The appeal is a provision to prefer an appeal before the president.
Yes, appellate authority is the president. And the
What post the petitioner was, writ petitioner was held, a writ petitioner held.
Engineer,
Chief.
assistant engineer. and
Yeah.
Public Works Department.
Which department?
Public Works
Public Works Department. He has been dismissed from service.
Now, discipline, continuation of discipline
No,
procedure after retirement.
But he has to be imposed with a major penalty.
major penalty.
To the, in the form of,
That
Reduction of pay.
Reduction in scale of payment.
against that appeal was preferred before the president.
Yes.
Yes.
Now, what order was passed by this court in this writ petition?
No,
By the learned tribunal.
tribunal.
No, so far this court has also heard this matter. This court means coordinate benches has heard this matter.
Tribunal application.
WPCT, my lord, challenging the tribunal. Although it's an old, it's only twenty.
Yes, tribunal application, this writ petition was
Has not been taken up, my lord, in that
It was
sense.
only for the.
for the first time.
direction
Not
to
first
issue,
time,
was
some
issued for
directions.
completion of
But it appears several orders were passed by the
Opposition-
coordinate benches on this writ petition.
Pleadings are,
For pleadings.
For pleadings.
completion of pleadings.
So
opposition.
no interim order, nothing.
No.
There is no scope for interim order. As the appeal is pending before the president.
Status, I'll apprise the
Let my
status.
learned friend come back next week, well, just only for the limit.
When the appeal was preferred.
But, it's was
2019.
2019.
20, right?
But usually,
More than 5 years.
And in the meantime, writ petitioner has retired.
That.
usually it takes a long time, my lord. President appeal usually takes a very long time.
That is pension
Just a minute.
benefits are also held up because the absence of vigilance clearances, pensionary benefits will not be settled.
Affidavit in opposition reply complete.
Yes.
As directed by the coordinate bench on 1st March 2024. And thereafter time was granted repeatedly. This is due to pendency of the appeal
No,
before the honorable president.
It was not called.
Sometime then it was mentioned and brought in the list.
This request I'm making for the first time, my lord, because I thought that it would subserve the ends of justice.
Yes.
my lord. Otherwise, nothing more than.
Let my learned friend come back, my lord, next week. If there's any development in the appeal, then appropriate orders can be passed.
Last it was heard by the coordinate bench on 15 January 2025. Headed by the bench, headed by Justice Madhuresh Prasad. Only time.
No, but para 2.13 says that thereafter applicant thereafter prepared an appeal dated such and such under rule 23 of such and such rule before the Honorable President of India, which was forwarded to Chief Secretary and in administration for appropriate attention.
No, but
So you will get instruction from Chief Secretary.
my lord, after that, my lord, presently it is pending, my lord, with the president, my lord. But what is the status, whether it has been disposed of? There is a committee of the central government which.
So the question remains, Mr. Tabez, that if appeal is pending, there is an appellate authority, that is the honorable president. Now, if the appeal is pending before the honorable president of India, in that event, why you have filed the writ petition during pendency of the appeal?
Right? Just the fact that it itself will take 10-15 minutes, well, it's not a check it.
Otherwise, normally in disciplinary proceedings matters, if the appellate authority is there, the writ petition.
Change of circumstances, few years back, what happened? This gentleman, my lord, was posted as assistant engineer in Campbell Bay, my lord. His senior was an executive engineer. He floated 2 tenders, my lord, for installation of statue of former late Prime Minister Indira Gandhi at Indira Point at Campbell Bay and related works there too, my lord. My lord, Lordships are aware that when a single work is executed, the work is executed in terms of the schedule of quantities indicated to the agreement, my lord. Now, as per the agreement, the materials were to be transported, my lord, to the site, my lord, by way of by ships, my lord,
Ships,
small
ships.
boats, my lord.
From Port Blair,
No, from Campbell.
from mainland.
Port Blair to Campbell Bay and then from Campbell Bay to that particular site, my lord.
So whenever a component is decided, my lord, the estimate is prepared, it's prepared on the taking into consideration the market value, the labor component, other factors. When the work was awarded, my lord, it was found that it is not possible to carry these materials by boats over there, but it has to be carried by head load, my lord. Till one particular point, by vehicles, by trucks, and
Physically, it was not possible.
then by physically. So therefore, the schedule of quantity of transporting the materials from boat was substituted by, to the extent that it has to be transported by head load, my lord.
Manually transferred.
Manually transport. So the component changes, substitution, it changes, my lord. So the cost factor there is different, the cost factor here becomes different. So whenever, my lord, under the CPWD manual, when there is a substitution of item, my lord, then there has to be reassessment of the value of the substituted item.
Has to be.
Has to be, my lord. Then somebody has to move a proposal as to what should be the value
Present value of the
that
work.
substituted item. And this gentleman, his only job was to prepare a proposal, my lord, for the substituted item, my lord. He prepares a proposal for the substituted item, which is forwarded to the executive engineer, and later on it goes to the superintending engineer, my lord. In the meantime, he submits certain bills, my lord, for payment. The executive engineer passes the bill and pays it to the contractor on the basis of the proposal which was submitted by me. I had only submitted a proposal. I have nobody, but only my proposal may be accepted, may not be accepted, may be right or wrong. But it was for the executive engineer to take a decision. The executive engineer passes the running bills, and my lord will also appreciate that all running bills under a civil contractor are provisional bills, my lord. The actual assessment and the calculation and settlement takes place in the final bill. If there is underpayment, if there is overpayment, so these the judgments of the Supreme Court on arbitration and all these, right, that all running bills are to be treated and considered as provisional bills, and the final bill is all the ultimate, and all settlement takes place there. So the executive engineer, my lord, he makes the payment on the basis of the proposal for the substituted item. But ultimately, what happens, the superintending engineer, he approves a rate which is less than what was proposed, my lord. So now an issue was cropped up that no, you have proposed something more than what the superintending engineer has approved, and therefore you have made an excess payment. So recovery was made from the contractor's running bill, nothing excess was payment. When recovery was made, my lord, what happens is that the contractor invokes arbitration, my lord. He says, no, this rate which has been approved by the superintending engineer is not justified, right, and correct because of the following reasons, because of the implications of the DSR, daily schedule of rates, the price index, and various other factors which is to be considered escalation and everything. In the arbitration proceeding, what happens, my lord, the arbitrator passes an award determining the value of the substituted item more than what was proposed by me, my lord. Department accepts the award, does not challenge it, my lord. So ultimately, the department even goes on paying the difference, the money more than what was proposed by me.
But the proposal was taken into consideration for initiation of proceedings against the assistant engineer.
As assistant engineer. In the meantime, my lord, what happened, and all these things.
But they will submit that it was in terms of the arbitral award.
Yes. So the justified amount was in terms of the arbitral award. They did not even challenge saying that it was high or low.
Arbitral award was complied with.
With.
That's why it has to be paid.
It was
now department is saying that they have suffered monetary loss because of this proposal.
They have in fact not paid more than.
And your contention is this was an interim measure. It has to be finally approved or disapproved.
Happened now. During the pendency of these matters, what happened? Even a CBI case is registered against some of the officers, the executive engineer, the divisional accountant, and the contractor. And while filing the charge sheet, the CBI recommends that a major penalty proceeding should be initiated against me. I'm not there in the charge sheet. I'm not an accused. Only a recommendation that proceeding should be initiated against me. On the basis of the recommendation of the CBI, this proceeding was initiated against me. The executive engineer of the contractor, they filed a discharge application before the Leonard Court of Session Judge.
No use of hearing you further today, because since we are not entering into the merit of the case, there's no use. It will be on the last date of the circuit, that is on 10th of February. In the meantime, you obtain instructions. I record an order. at the time of, during course of hearing, Mr. Shatardu Chakraborty, learned senior advocate representing the respondents, has apprised this court and appeal is pending against the order of the disciplinary authority.
Yes, yes.
An appeal is pending against the order of the disciplinary authority before the Honorable President of India. Stop. Accommodation is prayed for on behalf of the respondents to obtain instruction in order to apprise this court relating to the status of the appeal preferred by the petitioner against the order of punishment. Next paragraph. Next paragraph, a writ petitioner is represented by learned advocate. Next paragraph. List the matter.
My lord, let it be on 7th, my lord. 10th.
Why?
Some difficulty.
Why
I have
not
some
on-
difficulty on 10th, my lord. Let it be on 7th, my lord. I only have to apprise the status, my lord. Comments to your lord.
List the matter under the same heading on 7th February, 2025 in order to enable the learned advocate representing the respondents to obtain instructions.
I apologize, my lord. Some personal difficulty.
Yes, sir.
I wonder state of It off. Yes, call the list. Any mentioning?
WPA 39 of 2025.
Your Worship, I appoint a petitioner. I'm the respondent. Your Worship, an order was passed by the Deputy Commissioner imposing penalty upon me on the ground of illegal extra extraction of earth and boulders. For that penalty was imposed upon me. Order is at page number 18. I filed a review application. Page number 21 for certain facts could not be reviewed before the Deputy Commissioner, so I filed a review application in terms of regulation 34. Of the Andaman and Nicobar Land Holdings and Conservation.
Yes,
Some applications pending for disposal of.
review. The review is maintainable under the rules. Show me that review. Of 68 regulations. 66 regulations.
Regulation 34. Regulation 3 defines district revenue officer. It includes Deputy Commissioner.
Regulation 3.
It defines revenue officer. Means Deputy Commissioner.
B, 3B. So this is an order of Deputy Commissioner against which and review application was filed against the same authority. Have you annexed the copy of the review application?
Page number 20. Because the client has preferred your Worship, exact review or has not been used, re-examination was used. Page number 22.
21.
Last line, page number 22, last line.
So let this application be treated as review application and the decision to be taken on this reason. Matter is taken up, writ petition is heard in presence of the learned advocates representing the petitioner and respondent authorities. There is no private respondent. Respondent authority, stop. Ms. Nag, learned senior advocate representing the petitioner, submits that the petitioner has suffered an order dated 18 December 2024. An order dated 18 December 2024 passed by the Deputy Commissioner, South Andaman, whereby a penalty to the tune of rupees 124,88,000 was imposed on the allegation of illegal extraction and transportation of boulders. Stop. According to the petitioner, the order dated 18 December 2024 can be questioned by preferring a review application, not A, by preferring review application under section 34, under regulation 34 of the Andaman and Nicobar Islands Land Revenue and Land Reforms Regulation, 1966. Stop. Accordingly, petitioner made an application dated 12, made an application seeking review of the order dated 18 December 2024, and same was presented before the Deputy Commissioner, before the Deputy Commissioner, being respondent number 1 on 24th December 2024, as it appears from Annexure P4 to this writ petition. Stop. Petitioner prays for expeditious disposal of this review application. Next paragraph. Respondents are represented by Ms. Das, learned advocate, who submits that if review application is taken out by the petitioner, same may be considered in accordance with law. Next paragraph. Having considered the rival submissions made on behalf of the parties, writ petition stands disposed of, directing the Deputy Commissioner, South Andaman, being respondent number 1, to decide the review decide the application which was presented before, which was presented on 24th December 2024, upon treating the same as review application within a period of 90 days.
What they have done after this, instead of recovering.
Within a period of 6 weeks from the date of communication of this, within a period of 8 weeks from the date of communication of this order, after granting opportunity of hearing to the petitioner or his representative. Stop. The decision to be taken by the respondent number 1 shall be communicated to the petitioner by 10 days thereafter. Next, urgent xerox certificate. এটা পাঠিয়ে, এটা দিয়ে send it to my channel. Yes, next. Let me see what is the position given to service. 27 January it was filed. No, there is no private respondent.
Because my lord.
What is the matter about?
Compensation. No, sorry, this is yes. In the tsunami, my lord, businesses were affected. So, my lord, a scheme was brought out where under up to 2 lakhs, my lord, there was complete waiver on the loan and interest. And above 2 lakhs, my lords, only the waiver was limited to the interest component. Their contention is that they are entitled to full waiver of principal and interest.
Though the amount was beyond 2 lakhs,
Beyond.
below 2 lakhs.
Beyond.
No, beyond 2 lakhs. Up to 2 lakhs, a complete waiver.
Yes. So there is beyond 2 lakhs, they are still saying they are entitled. That's why.
So whether the representation on behalf of Union of India is required.
Is that the scheme is of the central government. That's what it is understood.
So we will come back on next Thursday. In the meantime, complete service. Serve notice who appears on behalf of the center, Mr. Tulsilal. So serve notice upon Mr. Tulsilal. Yes. Matter is taken up when matter is taken up for consideration when learned advocate representing the petitioner prays for accommodation to complete service of notice upon Union of India being respondent number 1. Stop. Other respondents are respondent number 1. Union of India being respondent number 1. Upon respondent, please read out the sentence. Upon Union of India being respondent number 1 as well as respondent number 3. Stop. However, other respondents are represented by learned advocate. Next paragraph. The learned advocate for the petitioner, you have not sent notice. Notice has to be sent. Learned advocate for the petitioner is directed to serve notice upon non-appearing respondents. Upon non-appearing respondents by fortnight from date and file affidavit of service on the next date. Next paragraph, list the matter under the same heading before the next available circuit after the time fixed herein above for completing service.
WPF for the sake of 125.
Answer the respondent.
Petitioner file an opposition before the respondent number 4 for mutating the land as per the testator.
You are representing all the respondents? Yes. Come this side, Ms. Das. Not from corner. Yes.
Sorry.
The petitioner files the representation before the respondent number 4 for mutating the land as per the
Mutation.
Yes, sir.
Yes.
As per the will was executed by his elder brother. After his demise, he filed the representation and used for the mutation. But the respondent authority is not taking any step for that. Therefore, direction can be given for disposing of the my representation.
Madam, may kindly come to page 38. Madam. There are disputed questions because the will has been challenged, my lord. They have filed one objection regarding the will. It's
Page
an
38.
unregistered will, my lord. Page 38. It's a notice issued by the Tehsildar.
But there is a notice to appear before the,
Yes.
before the tehsildar.
They are without appearing before the test.
You are hereby directed to appear on 10 January 2025.
But
So no decision has been taken.
Not taken.
because both the parties, all the parties has to come before, because there is an objection raised by the other legal heirs regarding the unregistered will. It was
Whether
a
any suit has been, whether the will has been challenged.
Still no, they not challenge this, any suit, Your Lordship.
only
Let
First-
my application may be disposed of.
Okay,
I'm
nothing
ready to
come into light.
appear before
No,
the
but the issue is, should be decided by the civil court.
civil court, yes.
That's what Tehsildar.
So how tehsildar can decide this
Lordship,
issue?
this will is,
It is on the, your claim is on the basis of unregistered will.
yes,
Unless and until the will is probated.
yes.
Where is the scope of passing order by the tehsildar? He is not a civil judge. He is an administrative authority. What decision he will take? And he have not made,
Here,
he have not made that another party who is challenging the will as party respondent.
Lordship, in these arguments, the probate is not required.
There
There is a judgment, Lordship.
Yes.
There is a judgment.
Division.
Probate is not required in this part of the country. The judgment by
Division bench judgment is there.
will be operated on the basis of death of the testator.
Yes, sir.
Yes. And unless it has been objected or any.
Then let it be decided by the tehsildar.
If the
After serving notice upon the petitioner as well as this afresh.
objection, then they have to.
Let the hearing can be completed.
So that is to be indicated in the order by the tehsildar.
Because as per the notice, if my lord sees, it's there that an objection has been raised by the other legal heirs. So my lord, if there is an
No,
objection.
what is your,
Tehsildar
since
cannot proceed with
whether the
it.
hearing was conducted on 10 January 2025.
They were not present at that time.
Petitioner was present. The other
But the other
side,
side was not.
not there.
Party-
My direction, my humble prayer is, my lordship, that
Problem is this,
not,
problem is this, that this Rajeshwari Kunwar
yes,
is not made party in this writ petition.
lordship,
Otherwise, court could have directed that the private party to appear before the tehsildar for taking at least a first decision. Tehsildar may pass an order accordingly.
yes, my,
But this party has not been added as a party. You add this this person as additional respondent, serve notice and come there.
lordship,
Otherwise, again, she will not appear. She will not appear before the tehsildar. What purpose would be served?
yes, lordship. My, is that let my application be disposed of in the Tahsildar with the appropriate hearing can be concluded. This is my humble prayer, the time board.
So no formal order was passed due to absence of the private party.
Notices were issued to both the parties since they are the legal.
Record an order. By presenting this writ petition, petitioner has prayed for mutation of the land measuring 0.0324 hectares as delineated in the notice dated 27 December 2024, which is at page 38 of the writ petition. However, on perusal of the said notice, it appears that one Rajeshwari Kunwar has filed an objection against prayer of the petitioner to have the land in question mutated. Stop. Since petitioner is praying for disposal of her application seeking mutation, a notice was issued on 27 December 2024 to the interested parties, including petitioner, to appear before the Tehsildar on 10th January 2025 for taking decision. Next paragraph. Ms. Das, learned advocate representing the concerned respondent authority or representing the respondent authorities, submits that on 10th January 2025, the petitioner appeared before the Tehsildar, but said Rajeshwari Kunbar did not appear. As a result thereof, decision could not be taken on the application of the petitioner. Next paragraph. Leave is granted to the learned advocate representing the petitioner to amend the post title of this writ petition and add Rajeshwari Kunbar as additional respondent in course of this day. In course of this day, and serve notice in and such additional respondent shall be served with notice including copy of this writ petition and the order passed today by 7 days thereafter. Next paragraph. List the matter under the same heading on Friday next, comma. February 2024.
Okay.
Item number 4.
My lord, I have very strong objection, my lord, to the maintainability of these writ petitions, my lord, 4 to 6, my lord. The third time that they are approaching the court, my lord, they have constructed a shutter on the public way, my lord, on the veranda. And every time an attempt is made to execute the order to just remove the shutter, they approach the court. Last 2 occasions, the Honorable Court directed that a hearing be
What
given.
purpose is being served by installing a shutter on veranda?
They want to basically
Make a partition.
improve their
It's a shutter made of which? Made of what?
metal. So, my lord, the only direction that this Honorable Court had passed is that we hear them. We issued notice, my lord, the municipality issued notice to them. They refused to, they appeared on the last day but did not sign. And before that, they said they kept using delaying tactics to delay the matter. Now, my lord, they have challenged that order. My lord, we'll file our
Which order? Order of the municipal.
Eventually filed to
Land advocate, your land friend submitted that they were not, or he was not granted opportunity to present his case.
3 years, my lord, every time a hearing notice is given, they seek an adjournment, my lord, on some pretext or the other. Now, the point is, my lord, the final order has been passed.
Where is that order?
That has been, it's annexed with the CAN application, my lord. We'll file, my lord, my humble.
Why can?
Because they did not annex it initially.
Submitted and they issue order, and that the same thing happened, and they came in front of the form and they have paid the order.
Kindly see page 19.
Yes, 29 January 2025.
Yes, ma'am.
Yes.
And
This is the order that has been passed. Now, we will, my lord, my only humble prayer, my lord, is that we will file our affidavit, my lord. But, my lord, this is only a temporary shutter, my lord. I strongly, my lord.
But in the meantime, if you remove the
shutter, their shop would be.
What remains?
No, but that can always be.
Then if you pay for filing of affidavit, then I have to stay the order of removal.
So then we argue without affidavit, my lord, in that.
Just a minute, let me go through the order. Who's the wrong in the order?
My lord, the very first thing is that I have sought an adjournment on the basis that because it is not the thing that they have not given permission of using that space to any other person. They have given that permission. I've enclosed with my dog that is in annexure page number 99, annexure P12. That permission has been given to 3 of the shopkeepers to use the open
First
space.
point is you are not given opportunity to present your case.
My lord, that's the
Come
thing.
to the first, as it appears from this order, on 21st January 2025, notice was given for hearing on 21st January 2025 at 8:30.
Okay.
That is wrong notice. On the same day at 8:30 p.m., the notice should not be given, fixing the date and time of hearing on the same date
Right.
at 8:30 p.m. at night. Now, you prayed for PM chamber with regard to so and the petitioner sent an application stating that one of his colleague had expired and he was unable to attend the hearing.
Right.
Then again, letter was issued on 22nd January 2025, acceding to your request. and a date of hearing was fixed on 22nd January 2025 to attend the hearing on 28th January 2025.
My lord.
For which the petitioner again gave a representation on 27th January 2025 for adjournment.
Yes.
So
My lord.
again, you sought
My-
for adjournment. Now a letter dated 20th January was again served to the petitioner directing him to attend hearing without fail. Failing which the matter shall be decided ex parte. After receiving letter on 20th January 2025, petitioner attended the hearing.
My lord, because my adjournment application was rejected. And
Rightly rejected.
it was rejected.
Repeatedly, it will not be allowed your
My-
adjournment.
It is not the thing.
You are trying to buy the time,
My
nothing
lord,
else.
it's not the thing. I have filed an
And
application.
it appears that you have encroached a veranda by installing a rolling shutter. Where is your right, show me?
My lord, yes, that is, that permission has been given to me. I will come to the
If
petition.
others were given permission, there is no concept of negative equality. If you have right to occupy or enjoy the possession of the veranda, then address this
My
issue
page
before
number
this
30
court.
page number 32. Page number 32. This is the order of
Page 32.
page number 32.
Yes, page 32.
In page number 32, the name, 33 also name, and 34 is the ordering portion. My lord, here the point number 2.
Yes,
Permission was granted to us to erect, to install rolling shutter.
but that is not in a veranda.
It is in the veranda. I will come, my lord.
Wherefrom it appears that it was permitted to
Subsequently,
install the rolling shutter at veranda.
There was two shutter. Point number, again we can come to point number 3, the cost of shutter being provided will be borne by you, and the shutter already provided by the council should be kept open during the business hour. There was two shutters. One shutter was in front of the shop that was installed by the municipal council, and subsequently this was the shutter, this was the permission. If already there is a shutter, why this permission was given? Point number 2. One shutter was already given by the municipal council, and this is the
No,
subsequent.
you show me that, yes, point number 2 deals with installation of shutter.
Yes.
That should be above the level of 76 centimeter from the
See,
on the floor.
yes.
Yes, because it says the dismantle the wall
This
from
shutter
sill level, that
Yes.
is 70 centimeter
from the
from
floor.
floor.
Without
Disturbing
structure of the
that
building.
structure of the building so as to erect and install
Install.
rolling shutters.
Yes.
Now, if now show me that this rolling shutter was permitted to be installed in the veranda.
My lord. My lord, page number 35 is the undertaking that is there, but
That
page
this
number-
shutter was directed to be installed in the veranda. Just a minute. Just a minute. That the fundamental matter was taken by the council and the council. To remove the hollow block wall and to fix glass or rolling shutter above the sill level.
Sill level.
What is sill level?
My lord, it is, my lord, it is up to the window, up to the from the floor till
To
window.
the window.
Window. My lord, this is the page number 39. That is the direction.
So, to fix the glass or rolling shutter up to the window level from the ground.
See page 44, their own document of 2014, they are saying that a representation was made that they may be allowed to do it in the veranda. Now, this is not fair on the part of my learned friend to refer to this document of 2011, because 2014 representation is at page 44, where my lord kindly see point 57. Shri K. Ganeshan, chairperson, stated that joint representation was received from tenants of shop number 1 to 9 at Mohanpura Vegetable Market, requesting to provide shutter facility in front of their respective shop. In the absence of such a shutter facility, stray animals, drunkards enter shop and spoil goods. After discussing, the committee unanimously recommended to accord permission to said tenants to provide shutters by incurring expenditure themselves. After installation of the shutter, the rent of the excess area should be worked out by revenue officer and concerned JR engineer, and then we fix the rent. So this shutter again is on the door. Now kindly see after this page 45.
Just a minute, and see from the time.
This is only a recommendation.
In front of the respective shop numbers 1 to 9. So that does not cover the veranda.
Page
My lord, it is not
Page
so.
45. Kindly see page 45, my lord. Since 18 December 2023, my lord, notices are being issued. Then they should have come earlier. Kindly see show cause notice 18 December 2023. Whereas it is found that you occupied veranda in front of your shop and has fixed rolling shutter without any permission. You are directed to reply to this notice. After this, they respond. Then, my lord, further notice issued.
Now, Mr. Chakraborty, one thing.
And they have to amend the writ.
There is a discussion on this issue. In your order at page 20 of the supplementary video.
My lord, the discussion, my lord, will see page, the second page.
So the point which you are raising is Adjournment as it appears, but there is a reflection from the order. Yeah, it appears that hurriedly this order was passed.
The order record.
So let me direct the authority to revisit again and pass an order taking into consideration the materials which are being pointed out by both the parties today. Because there is an order, we are not the technical persons so far installation of shutter is concerned. There is an order by the Revenue Officer Municipal Council dated 22nd October 2011 relating to installation of shutter, and another order is there that is at page 44. At page 44, agenda number 26, communication of the proceedings of subcommittee for finance, taxation and accounts meeting on 14 June 2014. Let these two materials be taken on record and a reasoned order should be passed, because they are the vendors and they are running their shops in Mohanpura market. Now, if this order is a cryptic order.
But madam, this order records that terms and conditions provided.
Now, where is the order passed by the Honorable High Court? In the
That is
previous
page
occasion?
number.
20, this is the order passed by the High Court on.
That was, that is in page number
95.
95.
Page 95.
We construct a shutter, my lord.
Change the information facts and concern.
Which is the common area, that's the concern. It is being. Very good.
By passing a reasoned order.
And this order is not.
Where are the reasons?
It is.
Let us come back to the passed by the court, because today if I permit you to remove the shutter, then that will be the final outcome of the issue. Now, before that, at least the shop owners, petitioners are at least to know that what are the reasons. Today there are two orders which are being placed before this court, one by your learned friend and another by yourself. That is at page 32 and 44. Both deals with rolling installation of rolling shutter. But the purpose is different. You are saying that the purpose is different, not occupying veranda. That should be reflected from the order. Let us come back to the order at page 20. Let us come back to the order at page 20. In view of the above, I hereby
No,
order.
my lord, above that means.
Yes,
Now,
yes.
therefore, in pursuance of judgment dated 17th January 2025, passed the Honorable High Court, Blair of the petition has been acceded for the following grounds. As per terms and conditions, passage or veranda shall be kept free from all encumbrance, and piling of goods at the veranda will not be allowed at any circumstance. In view of that the petition is an illegal occupation of veranda portion in front of his or her shop, and she has also installed a rolling shutter to cover the veranda space in unauthorized manner. Such illegal occupation has not only violated terms and conditions of allotment order, but also resulted in inconvenience to general public. So, my lord, this is not a.
What is the discussion with regard to these two materials?
This, the end of the day, my lord, this is terms and
No, no, but the shutter is to be removed on the, in terms of the order which is under challenge. By the dint of this order, let there be an order, a reasoned order. Taking into consideration these two documents, which is at page 34 and 44 of the writ petition. That why these two orders are not coming in aid of the petitioner, that should be demonstrated in the order.
executive authority, my lord.
So therefore, the executive authority, while removing the shutter and impinging upon the right of the party, they are required to pass on reasoned order. So revisit the issue, grant them adequate notice without any adjournment. Without no adjournment shall be granted, and matter to be decided on a particular date, and a reasoned order should be passed. And why these two materials, which are at page 32 and 34 of the writ petitions, are not supporting the case of the petitioner, should be indicated in the order. Writ petition is heard in presence of the learned advocates representing. Representing the petitioner and respondents. Stop. By presenting this writ petition, comma, inter alia, comma, order of the Secretary, Sri Vijaypuram Municipal Council, dated 29 January 2025, has been assailed. Stop. It has been submitted by the learned advocate representing the petitioner, that in terms of the order dated 17th January 2025, passed by a coordinate bench in the previous writ petition, concerned authority of council, Vijaypuram Municipal Council, within bracket hereinafter referred to as the state council. Concerned authority of the council is required to pass a reasoned order. In the order, in the impugned order, relevant materials as relied upon by the petitioner were not taken into consideration. Stop. In support of such submission, attention of this court has been drawn to page 34 and 44 of the writ petition, containing certain documents generated by the said council relating to fixation of shutters by the shopkeepers of Mohanpura vegetable market. Stop. According to the petitioner, these materials are relevant in deciding the issue involved, or in deciding the issue whether petitioner, being one of the shopkeepers of the said market, can maintain such rolling shutter or not, occupying veranda adjacent to the shop of the petitioner, or adjacent to the shop, occupying veranda adjacent to the shop. Next paragraph. Mr. Chakraborty, learned senior advocate representing the said council, has made submissions to defend the decision of the secretary of the said council dated 29 January 2025, and it is submitted that purpose of those two documents at page 34 and 44 of the writ petition, documents at page 34 and 44 of the writ petition, is completely different, that in no way authorize the petitioner to occupy the veranda by installing a rolling shutter. So according to the council, that was not the purport of aforesaid two relevant documents. Next paragraph. At first glance, on perusal of the impugned order dated 29 January 2025, issued by the Secretary of the State Council, it appears that the same is bereft of reasons. Stop. The coordinate bench, by giving direction as contained in order dated 17 January 2025, directed the concerned authority. What is this? What is this going on? কি বলছিলাম? Reasons. Then I said coordinate bench, by its order dated 17 January 2025, directed the concerned authority of the council to pass a reasoned order, which
Yes, you have not been complied with, it's two different.
document dated 21st/22nd October 2011, issued by the revenue officer of the then municipal council, which is at page 32, and another document containing decision in reference to agenda number 26. At page 44 of the petition. Stop. The concerned authority briefly should assign reasons as to why these documents are not applicable in the present case. If it is found after hearing the petitioner that say those documents are not relevant. Next slide. In view of aforesaid discussion, the impugned order dated 29 January 2025 is set aside, directing the concerned authority of Sri Vijayapuram Municipal Council to revisit the issue within a period of 4 weeks from the date of within a period of 4 weeks from date. Within a period of 4 weeks from date, shall I fix a date and time for hearing? Within a period of 4 weeks from date, after granting opportunity of hearing to the petitioner, and a reasoned decision shall be passed, which shall be communicated to the petitioner by 7 days there. Next paragraph, petitioner shall be put on 7 days notice prior to the date of hearing to be fixed, and petitioner shall not be granted any unnecessary adjournment except for reason which is beyond the control of the petitioner. Next paragraph. The writ petition stands disposed of. Urgent xerox of the copy. Why can? There is one can as it appears. To bring on record the order of the connected application being can 1 of 2025 is also disposed of. Yes. Same issue. The date of order is same. Show me the date of order, Mr. Chakraborty. Can is also there. Yes. Which page? Just tally whether the dates are matching. 29 January 2025. Now, what are those documents? Whether the pages of these documents are tallying? These two documents. Yes, one is at page 81. That will not tally. Yes, that will better. No, don't mention the page now. Two documents dated 21st/22nd October 2011, 21st/22nd October 2011, and another document at page 38. Just a minute. DP. describe this document, which is the second one, as confirmation of the proceedings against agenda number 26, which was communicated with a letter dated with a communication dated 4th August 2014. Please give me the previous notification. Don't indicate page number. Yes. So this is what I've said, that confirmation of the proceedings against agenda number 26. Yes, 4th August 2014. 4th August 2014. Same order. Because pages will not tell you anything. Same order. And the application is also disposed of. Yes, item number 6. Just a minute, let the record be placed with this. Yes, 29 January 2025 order. Then page 34, page 31. And another document, page 38. Yes, disposed of. Yes. Services. No scope for any interim order. Twelve percent to 18%. You are seeking. Yes. Now, but in the meantime, if recovery is made, what remains? When the recovery notice was issued, when the recovery notice was, show me that recovery notice. Second May, page. Where is the recovery notice? So let me add a rider that notice, the fate of this notice shall abide by the result of this writ petition. The writ petition is heard in presence of the learned advocates representing the petitioner and respondents. You are representing all the respondents, petitioner and respondent authorities. Stop. Next paragraph in the writ Stop. Next paragraph. Learned advocate representing the respondent authorities has submitted that there is no scope. Learned advocates representing the parties have jointly submitted that there is no scope for no, just strike it on. Having perused the impugned recovery notice dated 2nd May 2024, it appears that legality and validity of the said notice is required to be decided after calling for affidavits. Next slide. Let affidavit in opposition to this writ petition be filed by 4 weeks. By 4 weeks from date. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next slide. Petitioner shall be at liberty to mention the matter before the available circuit after the time fixed herein above or extend the writ. Next paragraph. The impugned notice dated 2nd May 2024 shall abide by the result of this writ petition. Yes. Not today. Who is your senior? Where is he? In the morning he was there. Not today. Yes. Not today. Not today. Place the record before this before me. Both are claiming benefits. So what? Whether you have the entitlement in accordance with law or not, that has to be examined by this court. Decision of the authority is not sacrosanct since the writ petition has been filed challenging the decision of the authority. You are representing petitioner in which respondent? In which writ petition? WPA 198 of 2024. 10. So you want to file reply. In your writ petition, affidavits are complete. Both the writ petitions are taken up for consideration. When learned advocate representing the petitioner in WPA 198 of 2024 has prayed for extension of time to file affidavit in reply. Next paragraph. Time to file affidavit in reply stands extended by 2 weeks. Stop. It stands extended by 2 weeks as a last chance. As a last, since other matter is ready for hearing, as a last chance. Stop. Next paragraph. List the matter before the next available. List both the matters before the next available circuit after the time fixed herein above for filing affidavit. For filing affidavit in reply on extension. On extension. Next. Not today. Yes, Mr. Joypal. Let me see, let the record be placed. But already there was an extension. As prayed for on behalf of the petitioner, as prayed for on behalf of the petitioner, time to file affidavit. Time to file affidavit and reply is extended by 2 weeks as a last chance. Stop. List the matter before the next available circuit after the time fixed herein above for filing affidavit and reply on extension. Where is Mr. Prasant? Not today. From 14 to 16, not today. Who is for the petitioner, Mr. Subhabalan? Not today. Tell Mr. Prasant to appear on the next date. No, no, one after another. 18 and 19 appearing analogously. But as a last chance, a reply was, affidavit reply was, time to file affidavit reply was extended by 30th January 2025. Come back on Tuesday, Wednesday, let me see. No. Then I have to, in the meantime, you can file, otherwise I have to impose cost. Not much, 5,000 rupees to be deposited with the state legal services office. Not to Mr. Shivabalan's client, but with the services authority. Yes. Same order was passed previously by 30th. Not today. Same order, by 30th. Not today. Not today, Mr. Mishra. Let me see. By 30th. Same order by 30th January, it was directed to be filed. Well, let me see. No, previous matter, I found that I have passed an order by 30th January. That is not the case in the present matter. As per so you have not filed reply. So let it be extended. Record an order. time to file affidavit in reply as prayed for on behalf of the petitioner is extended by 2 weeks. Stop. List the matter under the heading hearing before the next available circuit after the time fixed herein above for filing affidavit in reply on extension. This is 21. 22, yes. Let me see. Where is she? Let me see if it is. You have not filed opposition. Well, come back on Wednesday. That will be in presence of the learned advocate representing the petition. Not today.